we're very fortunate today to have with us Professor Kent Roach, who is a professor of law, as you may know, at the University of Toronto down the road. He's also Pritchard Wilson Chair of Law and Public Policy at the said University of Toronto. And he, in fact, graduated from that university as well as from Yale University, and was a clerk to Justice Bertha Wilson of the Supreme Court of Canada. He's been the editor of many famed journals in the field, including the Criminal Law Quarterly. He's a fellow of the Royal Society. In fact, I could list a number of
please don't.
Of accolades that he's received, Royal Society and so forth. He's also published over 13 books, and we learned at lunch that he's working yet on another. So one of the most prolific authors, I want to say, in the legal field, all fields confounded here in Canada. So really a giant of the law in this country, but also really I want to say a father figure in criminal law for many of us, because Kent has been a trailblazer in many sort of sub fields of criminal law and over beyond criminal law, writing on judges' biographies, working on issues of remedies more generally, questions of human rights, questions of counterterrorism, and so on and so forth. So I'm going to stop here because really he's one of these people that I could talk about for hours. Simply to say that he's agreed to come and speak to us about some of his current work and to present a paper entitled The Meaning of a Miscarriage of Justice and Comparative Miscarriages of Justice, which is a topic that really, unfortunately, has received very little attention to date in this country. And so we're really glad, Kent, that you're with us today to present your groundbreaking work once again. So thank you very much.
Well, thank you very much for that generous introduction and for the invitation. It's great to be here. I don't know about being a father figure. It makes me feel a bit old, but that's probably par for the course. What you're going to hear today is actually a little bit experimental. I'm going to speak to a paper that I have written which deals with this issue of should we study wrongful convictions, factual innocence, or should we be more concerned about broader miscarriages of justice? But I'm also going to talk about what I hope will be some ongoing work for myself, looking at what comparative law has to offer with respect to this field of, I'll say for want of a better word, wrongful convictions. Now, as some of you may be aware, there has been a burgeoning scholarship on wrongful convictions. Richard Leo has been a particularly influential scholar, not only in his work on false confessions, but in calling on scholars to kind of reconceptualize the field of wrongful convictions. So in 2005, he wrote a very famous article calling for a sociology of wrongful convictions. And in 2017, he updated that article and concluded that scholars, mostly American scholars, have upped their game when it came to writing about wrongful convictions. He talks about, obviously, the role of social science, many social sciences, psychology, relevant to wrongful conviction, but also the growth of big picture and subject matter discussions of wrongful convictions to kind of even out what had historically been an emphasis on case studies. But one of the things that Richard Leo leaves out in his 2017, as indeed in his 2005, is what is the role for comparative studies of wrongful convictions. Now, just this year, two scholars who I know and I respect, wrote two papers that made me nevertheless deeply uneasy. The first is Mark Gotze, who wrote a paper called A Global Innocence Movement. And the second is Brandon Garrett, who is, any of you familiar with wrongful convictions will know that he's really one of the stars in the United States, wrote a very important book, Convicting the Innocent, based on the first 200 DNA exonerations, wrote and published a paper in the California Law Review called Towards an International Claim of Innocence. And both Professor Gotze and Garrett make the claim that there is a growing convergence crossing traditional lines between civilian and common law systems and expanding over virtually all continents towards a global innocence movement, Gotze's phrase, or what Garrett argues is an international right to claim innocence. And why am I a bit troubled by that? Well, it seems to me that this idea that there is a growing convergence, if you go back to Mark Tushnet's, I think, very helpful taxonomy of comparative law, where he talks about comparative law being often about either functional similarities across different legal systems or expressive differences. Both Gotze and Garrett are stressing the functional similarities in wrongful convictions across the globe. And there is something, I think, important and powerful there. So both of them say, if eyewitnesses get it wrong in the United States, then they'll get it wrong in Canada and Germany and Singapore, wherever. And so there is something to that. But I guess what I find troubling, and one of the things that I kind of want to examine in this paper and hopefully in later work, is they are basing their claims, and both of them I think are very upfront about this, in the American innocence movement. And certainly if you look at criminal justice writing, there is a very strong strain that the American criminal justice system is exceptional and perhaps actually exceptionally bad in some ways when it comes to mass imprisonment, gross disparities of racial overrepresentation, populism mobilized against the rights of the accused, the rights of felons to vote, and so forth. And so for me, this raises the question of can you take the good, right? Because, one of the things, I don't want to argue against the American innocence movement. I think that, many people, including Gotze and Garrett and Scheck and Neufeld and many, many other people have done wonderful work in the American criminal justice system that has been not totally unproblematic, but I think quite progressive. But the question for me is, can you have that good of an American-style innocence movement without taking the bad of an American criminal justice system that uses the death penalty, that has many mandatory minimums, racism, extreme localism, extreme populism? So how do you disentangle those two? And so my kind of preliminary hypothesis is that an American-style innocence reform, if implemented uncritically, can have regressive effects on criminal justice systems that are more restrained than the American criminal justice system, which would virtually be almost all of the criminal justice systems that you can think about, except maybe China. And I am going to talk about China because that's one of the places where this innocence movement and concern about wrongful convictions is gaining ground. Now, as a kind of sub-thesis, right, this would suggest, and this is something that some of you here may be working with the Osgoode Innocence Project, which has done important and good work, but I think raises a question, and that is that innocence projects outside of the United States. And I mean no criticism of the Osgoode project or really any other project in Canada, Australia, and the UK have often, frankly, struggled to produce the same sort of exonerations that in the United States have resulted in 340 DNA exonerations, and with the US Registry of Exonerations now over 2,000 registered exonerations since 1989. Right? And so I think that this may actually address a question that I find when I talk to colleagues working on innocence projects in Australia, colleagues working on innocence projects in the UK, colleagues here in Canada. Yes, we are finding cases. Yes, wrongful convictions exist. I don't in any way want to promote a sense of complacency, but if we're using an American template and the American criminal justice system is exceptional, if you accept that, then maybe it's not passing strange that the non-American innocence projects have not been able to replicate the success of American innocence projects. It's not to mean that they're not worthy endeavors. But again, I think that, in terms of comparative law, as Tushnet reminds us, you always have to balance yourself between what is functionally similar and what is expressively different. Okay? So moving on, let's talk at the most basic level, and I apologize if it seems semantic, but I think it is very important. What is a miscarriage of justice? What is a wrongful conviction? And I guess my hypothesis would be that outside of the United States, you're much more likely to hear the language of miscarriage of justice, whereas in the United States, you are much more likely to hear the language of wrongful conviction / factual innocence. And here, the most influential, and it is a very broad definition of miscarriage of justice, is the English scholar Clive Walker's definition of miscarriage of justice, which he defines as an individualistic, rights-based approach to miscarriage of justice. And he says this happens whenever suspects or defendants or convicts are treated by the state in breach of their rights, whether because of deficient processes, the laws which are applied to them, or because there's no factual justification for the applied treatment or punishment. So he's not oblivious to factual innocence, but he's adding a lot more. Or whenever suspects or defendants or convicts are treated adversely by the state to a disproportionate extent in comparison with the need to protect the rights of others. So a very kind of sweeping definition of miscarriage of justice. And you compare that with, say, Actual Innocence, which I believe was the title of Scheck and Neufeld's seminal book about the innocence movement, where they define actual innocence as cases where there is definitive evidence that the suspect did not commit the crime. Most often through DNA samples found at the scene of the crime that do not match the accused. Even if you just move to at the level of law, right? We know in Canada under Mullins-Johnson that rightly or wrongly the Canadian courts have said we do not have jurisdiction to make declarations of factual innocence, right? Innocence is not a recognized category in Canadian criminal law. Now, innocence has had much more of an inroads in American law, right? That innocence first made inroads into American law as a way to restrain habeas corpus applications that were out of time. So you had to demonstrate not only that your rights were violated, but that you might actually be innocent. So as Carol and Jordan Stryker have written about, innocence was actually used as a way to restrain habeas corpus. But if you look at, I was looking at the California Penal Code, which is gargantuan, but there are declarations of factual innocence. So the thing that Bill Mullins-Johnson was looking for in Canada is actually available in California. So, depending on your perspective, that may or may not be a good thing. And then finally, if you look at the only American example of something like the Criminal Case Review Commission, a dedicated agency with powers to refer cases back to the courts, the one that exists in the United States, the North Carolina Innocence Inquiry Commission, is one that is restricted to claims of factual innocence. So, again, it seems to me that that imposing an innocence paradigm onto a legal system, like most legal systems outside the United States that I'm aware of, that does not recognize innocence, can be a recipe in frustration, right? And of course, some of you may be familiar with a debate that has been raging the last 7 or 8 years in the United Kingdom between university-based innocence projects in the United Kingdom and the Criminal Case Review Commission on the basis that the innocence projects, inspired by the American models, are saying we're about discovery and vindication of factual innocence. The CCRC and the Court of Appeal saying, well, I'm sorry, like in Canada, innocence is not a legal category that we recognize. The issue is safety. And this has led to, a very kind of tense battle where some people in innocence projects in the UK universities have gone so far as to say, well, maybe we need to get rid of the CCRC because it's not concerned enough with innocence. And the CCRC and the Court of Appeal have been perhaps more hostile than they should have been to the important work that the university innocence-based projects have done. Because, of course, the CCRC is, as you know, an administrative agency, like any administrative agency, is fallible, especially when its budget declines and the number of applications goes up and it has a 96% rejection rate of those who apply to the CCRC asking for their convictions to be reopened and sent back to the court. Now, another reason to study these different meanings of what a miscarriage of justice is that they're not written in stone, right? So the fact that outside the United States, the factual innocence category has not yet gotten a hold doesn't mean that that is always going to be so. And I would kind of cite perhaps two examples. And that is, even though the UK doesn't recognize innocence as a category in terms of criminal appeals, innocence reasoning, and of course the converse, factual guilt reasoning, has influenced at least two developments in the UK, both of which in the UK context, and this goes back to my original thesis, I view as quite regressive. So the first is the abrogation of double jeopardy rules in the UK in 2003, right? So one of my concerns about factual innocence is the flip of factual innocence is factual guilt, right? So it is, and Nobles and Schiff have recognized this from the beginning, it is a discourse that is hostile to kind of due process. And one of the things that happened in 2003 is the British allowed the abrogation of double jeopardy if new evidence has emerged of factual guilt, right? So, that's an example where if you play with factual innocence, can you avoid the flip side of it, which is factual guilt? Isn't to say that that's wholly unprogressive, because one of the things that has happened is in some Australian states, they've used abrogation of double jeopardy that allows the Crown to reopen cases after acquittals when there is new evidence of guilt. They've been able to flip that and get a second right of appeal in cases of new and compelling evidence of innocence, right? So again, it does work, but you have to realize that, you're playing a game that could have regressive effects if you are concerned with the rights of the accused. The second example in the UK is over the last 10 years, they have changed their system of compensation for those who are wrongfully convicted to require proof of factual innocence. So, one of my reasons why I'm in a slightly awkward position of, having some cautionary notes about this kind of growth of a global innocence movement that is being celebrated is, again, I think it can have some regressive effects depending upon where the starting points are. Another example closer to home, which shows, I think, a traction or growth of a factual innocence model is the differing reactions to the Omar, Khadr and Maher Arar settlements, right? So if you go back to the Arar Commission report, what Justice O'Connor does is come about as close as possible as declaring Mr. Arar to be factually innocent. So Justice O'Connor's conclusions were that he had seen no evidence that suggested that Maher Arar was guilty of a national security threat or a threat of national security. Now, not everyone agreed with the subsequent $10.5 million settlement with Mr. Arar, but I think most of us would acknowledge that there was much less resistance to that than there was to the similar settlement given to Omar Khadr, even though his rights, his charter rights, the Supreme Court of Canada had in two different decisions said was clearly violated. And even though Mr. Khadr's guilty plea in the military commission really has all the indicia of a false guilty plea, which is also a new phenomena in wrongful convictions, people making rational or irrational decisions to plead guilty. So that's my overall argument about the meaning of a miscarriage of justice vis-a-vis actual innocence or factual innocence. And the fact that I myself find the miscarriage of the broader miscarriage of justice rubric to be much better, much more attractive. In the time remaining to me, and it's quite brief, I just want to much more tentatively sketch out why, although I think we need to have caution in applying an American template of innocent scholarship, I do think that a comparative examination of wrongful convictions can actually contribute to our understandings of wrongful convictions. And it's something that in the years ahead, I hope to devote, to be able to devote more time to. What can comparative law show us? Okay, well, first of all, much of the examination that Garrett and Gotze do, and much of the literature on wrongful conviction has been focused on what the causes of wrongful convictions are. I think a gap in the literature, and one where comparative law can really contribute, is what is the responses to wrongful convictions and how do they differ? And here I would suggest, that, say, comparing the UK and Australia on one hand and Canada's response to something like false confessions opens up our sense of imagination. Because both in the UK and in Australia, the response to concerns about false confessions and abuse during interrogations that can lead people to falsely confess have been dominated by a legislative response. PACE and similar legislation in some Australian states, supplemented by a guide to practice. Whereas if you look in Canada, the criminal code is silent on interrogation practice. We rather rely upon case-by-case adjudication, which in some ways makes us a little bit more like the United States, although even in the United States, there are a number of states that have more statutory regulation. So it seems to me that comparative law can help us understand both the effectiveness, but also why from certain from certain starting points, including political and legal culture, why some countries will look to legislation as protection against wrongful conviction, whereas other countries, and I think Canada particularly, has tended in the last 20 or 30 years, partly because of the Charter, to look to the courts as the main repository of remedies against wrongful convictions. Similarly, you could see similar strains of this with respect to expert forensic evidence, which plays an important role in wrongful convictions, where Canada's response has been to attempt a little bit to tighten up the gatekeeper role in cases like Abbey and White Burgess, where in the United States, and partly because of a perception that the Daubert standard hasn't really been very effective, there's been much more of a focus on the political economy of forensics. That is, how is it practiced? But of course, the political economy of forensics in the United States is far more localized than it is in Canada. And then finally, it seems to me that comparative law can allow us to have a more refined understanding of what the causes of wrongful convictions are. So if you look at any kind of generic list of causes, you'll see false eyewitness identification as one of the leading causes. And in fact, that's one of the ones that Professor Gotze says this is one of the reasons why we need a global innocence movement. If eyewitnesses are getting it wrong in the United States, then they must be getting it wrong in Germany and elsewhere. But if you unpack that a little bit, right, a large part of the false eyewitness identification in the United States are, especially in the DNA cases, 47% African American males being misidentified, often in sexual assault context, and then being subject to such long terms of imprisonment that it makes it possible and feasible for them to eventually be exonerated, right? Because there's an access to justice issue, right? So again, to go back to that point about why do non-American innocence projects not seem to be able to replicate the success of American innocence projects? Well, one reason might simply be that most people are out of prison and the incentive structures then become extremely different, right? So both the American death penalty and the American sentencing practices actually contribute to the exoneration rate. Or similarly, if you think about guilty plea wrongful convictions, obviously something that has happened in Canada. We know from the Simon Marshall, the Dr. Smith cases, the Anthony Hannemeyer case. But in 2016, 74 of the 166 exonerations that were added to the American registry were because of guilty plea wrongful convictions. Well, again, to fully understand that, you have to understand bail practices, mandatory sentence, the charge structure in the United States, which may facilitate guilty plea wrongful convictions even more than, say, Canadian and other laws do. So in conclusion, although I see some virtues in applying a generic wrongful conviction template drawn from the American innocence movement, especially in raising awareness about wrongful convictions in systems that may not recognize them, I also worry that it could have regressive effects. The focus on DNA, that can be very much a double-edged sword. Think of Mitt Romney's task force, which proposed a kind of, certain a constitutional death penalty that would be based on kind of scientific certainty. Imagine if that DNA focus was taken to a jurisdiction such as China, or another one. So I think that we should approach this idea of a global innocence movement with some degree of caution that, yes, draws upon the functional similarities where they exist, but is more attentive to the differences and the exceptionalism of the American criminal justice system that has produced that innocence movement. Thank you very much.
We have lots of time for questions. As you know, this is being recorded, so before you ask your question, make sure that you have a microphone in hand so that your voice can be heard. Yes, please go ahead.
Thank you for this so much for that, Professor Roach. I had a sort of question about your final conclusions.
Right.
Obviously, I can see that American prison sentences are much longer than
Yep.
prison sentences virtually probably anywhere else. But it's not obvious to me that the racial disparity is not helpful with respect to understanding miscarriages of justice in the other countries you refer to. So, I mean, the evidence I recall from Germany is that, in fact, it's equally racialized just with respect to different racial groups. So whereas you might see African Americans disproportionately prosecuted and victims of miscarriages of justice in the United States, you tend to see that for Turks and Arabs in Germany, and I'm inclined to believe that holds mutatis mutandis for other European countries. I'm just not as familiar with the literature.
Yeah, no. I mean, look, and I've written about indigenous wrongful convictions in both Australia and Canada. So my point is not that there are not racial disparities in wrongful convictions, but rather that we need to adjust them to the particular context of the country. I mean, one of the things that I found with indigenous overrepresentation in Australia and Canada is we may, in some ways, even have a bigger problem because if you define the population at risk of wrongful convictions as a crude kind of proxy as the prison population, right? So what you have in the United States is you have African Americans are overrepresented in prison, but they are even more overrepresented among the exonerated. So I think it's about, somewhere south of 40% in prison and somewhat south of 50% among the exonerated. So that shows that African Americans, even in proportion to the prison population, are more vulnerable to wrongful conviction, but it also shows that they are getting access to exonerations. Where in Canada, again, and it's complicated by time lags, but if in Canada and Australia you take the base indigenous prison population is somewhere between 20 and 30%. Among recognized wrongful convictions, there's actually less than 20 or 30%. Now, you could say, well, maybe that's this criminal justice system is all of a sudden unfair to indigenous people in every other respect, but is pretty good about wrongfully convicting them. That seems to me to be implausible. So it also seems to me that that's a story about potential lack of access to justice, right? Because it may be that the kind of wrongful convictions that indigenous people in Canada and perhaps Australia experience are just not getting picked up by Innocence Projects to the same degree that African American wrongful convictions seem to be being picked up by American Innocence Projects and other kind of pro bono. So again, I mean, it isn't that you shouldn't. I also think it's a fair criticism, though, of the American Innocence Movement is that its consciousness of the centrality of race has, I think, been fairly late in coming. And really has been through the work of the National Registry on Exoneration and Sam Gross and a few other people. But even if you go back 5 or 7 years, race was perhaps not as central in the discussion of American wrongful convictions as perhaps it ought to have been.
Ken, thanks so much. So interesting. And two things. One, sort of a comment that I wonder how you'd react to it at the level of kind of concept, more offering than anything. Another, just a question about lessons that you draw from your point. So I found it really interesting. It really struck me that we begin with a call for a sociology of wrongful conviction.
Right.
And then a call for a global innocence project, which of course seem, and I think in a sense, and this is sort of the offering, seems like you're actually just remaking the call for a sociology of wrongful conviction in a sense, to the extent that the pathologies you see in a global wrongful conviction movement or a global innocence movement are in fact the failures of not having done the sociology of wrongful conviction, right?
Right.
So in some interesting way, the global innocence kind of movement is evidence that the sociology of wrongful convictions actually hasn't been done. So although you say people have stepped up their game,
right.
in a way I wonder actually
right.
if this is just evidence that that's not really happening.
Right.
That you can't
right.
tell a sociology of wrongful conviction without, that is disaggregated from capital punishment, from race, from these sorts of, so from remedy, from race, from structural design, from trust in judiciary, from a whole range of things. So I find that really appealing, actually, just about the paper. In a way, it's kind of pushing people back to the original call and what it would mean to take seriously a sociology of wrongful conviction. And that led to something which you said that I thought was quite interesting in the end, and my question, which is, if you were to kind of take the caution of an Americanized
yep.
Vision of wrongful conviction, and take the lessons of those dangers, and then kind of craft what a miscarriage of justice project would look like in a place like Canada. Like, what would that look like if we didn't do the Innocence Projects quite in the same way?
Right.
What do you think lessons we would take from that? How would it look different than the American Innocence Project? Because, to be frank, I can't really blame, in
right.
a system in which
no.
capital punishment exists, the notion
exactly.
of an access to justice focused on innocence at the end of possible capital punishment is
yep.
a pretty rational response
yep.
in design.
Yep.
But it produces these distortions
yep.
in a system with all these changes. So what would a sort of miscarriage of justice project look like? What would its access problems look like? What would you do with a team of students
right.
doing a proper miscarriage of justice rather than innocence project?
Well, thanks. Those are great observations and great questions. I think that you're probably right, is that in some ways what I'm calling for is a national sociology as comparative method. And the example that I didn't get a chance to get to is there's been this explosion of writing about wrongful convictions in the People's Republic of China. And I'm complicit with this. I mean, I went over and I gave lectures and, stuff like that. But, it is this kind of missing sociology when you apply a kind of, it's almost a sanitizing template to say every system has wrongful convictions. China, like everyone else, and because they've had a number of celebrated cases where the victims have turned up alive. Whereas the more I read about the experience in the PRC, it really boils down to torture, 99.9% clearance rate, lack of judicial independence, lack of police independence, lack of prosecutorial independence.
Lack of presumption of innocence.
Lack of presumption of innocence, So, but there are a lot of us, and as I say, I've been partially complicit, who kind of want to take this template and travel with it abroad. So, your second question is then, well, what does a more sociologically informed Innocence Project or really Miscarriage of Justice Project look like? And I think in Canada, and this is something this year for the first time, I taught my wrongful conviction class with a colleague, Amanda Carling, who worked with Innocence Canada for 4 years. Had previously taken the course, but also comes at it from the perspective of a Métis woman. And I think a miscarriage of justice projects, it would be projects in Canada, and it would probably look more like community legal clinics. So there would be a miscarriage. There's an Indigenous person's miscarriage of justice project, and of course Emma Cunliffe and Deborah Parks has written about how an Indigenous woman who pleads guilty to manslaughter, who might have a Lavallee defense, is not factually innocent and is going to have problems being represented by a traditional innocence project. That person needs to be represented by someone with cross-cultural competence. Similarly, you think about Simon Marshall's case and the problem of people living with mental disabilities. And I think that if you had that structure, you would also have people saying, look, the issue is not simply the wrongfully convicted. What about the rightfully convicted? Because those people with the same characteristics are still treated badly, right? So to a certain extent, and again, I hesitate to say this because I do think, I agree with you completely that if I'm in the United States, this looks like, innocence work looks like pretty good work for me to do. But there is a sense that the innocence work is kind of the flip side of victims' rights, right? That if you think of a punitive American system where the crime victim has such a kind of emotional pull and demand on policy, what's the only thing that could possibly match that? Well, the only thing that could possibly match that is the person who is factually innocent and has been in prison for 20 or 30 years, often because of poverty, race, disability, whatever. And so one of the problems with the innocence movement is it looks for good victims, right? That's the problem with victims' rights. Isn't that we shouldn't care about victims, but that we idealize victims and we make victims represent a certain idealized sort of thing. And if you read American victim compensation statutes, if you read even DNA Access Act, you see these kind of the good victim sort of things. So, we'll give you compensation, but, you shouldn't have any prior felonies, and you shouldn't have played any role, and for sure you shouldn't have pled guilty. You have to be the good victim. And so to go back to Ben's point, I think a miscarriage of justice project is one that is kind of much more holistic and says, look, we know from the wrongfully convicted that people who come out of jails are damaged, but maybe some of that damage happens to people even that aren't wrongfully convicted that are in those jails. But the problem is it's a lot easier to raise money for an Innocence Project than it is for a Miscarriage of Justice project, because a Miscarriage of Justice project gets you into, well, this is, technicalities, this is rights. And this is why, although, Clive Walker, I think his definition of Miscarriage of Justice is very normatively compelling, I'm not sure history is on its side. Because I think in a world where there's growing punitiveness, growing populism, it's just that factual innocence model, and this is not only a point about the United States, this is a global point, and we've seen it grow in the UK. I think it could grow here. One of the things that I'm concerned about is if we regularize our system for compensating the wrongfully convicted, which for all kinds of rules of law reasons we should, but I worry that right now in this climate, it would just solidify a factual innocence sort of mandate. Anyway, thanks.
Let me take my phone now. So one of the worries of people who are trying to theorize criminal procedure is that it's vastly different between countries, and it's historically contingent, and it's very hard to generalize the way it is as opposed to what it would be with respect to substantive criminal law. So listening to your presentation and talking about U.S. exceptionalism and why the claim for innocence might do more work there, I find myself thinking, I find myself wondering whether that's actually accurate. It's accurate as a matter of fact. It's true that there are innocence projects there, and given that penalty, that has gotten traction that it might not gotten elsewhere. But at the same time, when I think, so you spoke mostly of Anglo-American jurisdictions. You mentioned Germany and China. One of the particularities of the inquisitorial system is that it's pretty much geared to the truth, right? That's what we're trying to get at. There are a lot less rights that are there to encumber the process. In countries like Germany, it's pretty much the case, at least on the books. Plea bargaining is not something that comes along the way to corrupt the process. And so one might think innocence is really what it's about there. Whereas in the US, where 95% of the cases do not make it to trial, and people plead guilty based on all sorts of frivolous considerations, possibly coercion, etc., that is not surveyed, innocence is not really the problem there. It is in the sense that death penalty is something that we should try to work around. We don't want innocence to die, but really the bulk of the issues are not so much about innocence, but just the miscarriages of justice, right? So I'm wondering whether the emphasis is not skewed by saying innocence US and miscarriages of justice elsewhere, as opposed to saying the reverse, right? So the US is not really about innocence. Is there just as a kind of a slogan that has worked with respect to some cases, but what's really needed there is miscarriages of justice, where it might be easier in Germany to say innocence is what should drive the movement or the popular position.
I mean that's interesting, because although it may not fit with all of the aspects of my thesis, it may also pick up, what I was saying is we don't see the success of innocence projects in continental Europe. I mean, they do have some successes, but not even on a per capita of the magnitude as the US. So I think what you're saying is, well, this may actually represent the fact that those systems are doing not a perfect, because no system will be perfect, but a better job of getting at truth, because that is closer to what they are concerned with, right? I think that there's something to that. I mean, to be fair, though, both Garrett and Gotze are very skeptical about the civilian common law divide, and they both look to, I think, France, which in a number of reforms, I think after Octroi and in 2014, has actually they would argue have been more willing to allow revisions. But again, I like your point, because it kind of goes back to the exceptional, like I actually don't think your point is contrary to the exceptional in the American system. I mean, what the American system is this heavily plea bargain kind of due process sort of obstacle course that truth is at most a kind of secondary concern. And of course, for Canada, one of our worries are we becoming more like the American horse, right? And then this also goes back to the point of what is the technology of prevention, right? So I mean, certainly people like Craig Bradley's critique of the due process revolution. I have a lot of time for that. And if someone said, would you rather have an Oikle, especially if there's a Singh and a Spencer with it, or would you rather have pace? I would rather have pace, right? And so there's an issue of whether we're getting caught in a slipstream. But having said that, again, I mean, Innocence Canada and other projects, and it looks like there's going to be a big wrongful conviction coming from the UBC Innocence Project. But I think we do have to concede that it's not, even on a per capita basis, it's not of the same magnitude as what is happening in the United States. And maybe what we need to do is stop hitting ourselves over the head with that and saying, well, we're just not looking hard enough, we're not working hard enough. It just may be that the Americans have to, till, unfortunately for them and for the wrongfully convicted, more fertile soil. But again, I don't want to say that in any way to suggest complacency, right? Because I mean, there are obviously wrongful convictions here.
Professor Dufresne.
Yeah, I wanted to just ask a little bit more about those court-driven types of responses to the causes of wrongful convictions. And so you've mentioned the confessions rule, for example, as being directed partly in Canada toward the prevention of false confessions and the fact that they would lead to wrongful convictions. One of the things I find interesting about the confessions rule in Canada is that it's a kind of hybrid rule when you look at the question of factual innocence on the one hand and due process on the other, because a confession can be rendered involuntary for reasons that are associated with it being unreliable and causing wrongful convictions, or it can be rendered involuntary for reasons associated more with due process types of concerns. And I think we see the same kind of hybrid rule having been adopted by the Supreme Court of Canada in the Hart case in 2014 with respect to Mr. Big confessions in the Mr. Big sting type of operations, where the court says, well, first we'll consider excluding these because they're unreliable, but even if they're not unreliable, we can also exclude them when they're abuses of process, and that's a completely separate due process type of question. And so my question for you is, do you think those kinds of tests that are very broad and hybrid in that sense that Canada tends to like? We seem to like having tests that bring in innocence among other types of factors. Are they incoherent? Do those kinds of tests actually undermine the due process part of it, right? This is what my former colleague Don Stewart said about Hart when it came out. He said, why all this stuff about reliability? All we need is abuse of process. Why aren't we just talking about whether we're abusing the process and we shouldn't be concerned about reliability because that undermines it and it plays to this populist notion that all we care about are people who are factually innocent. So I just wondered, given that the state of the law in Canada does rely on these kinds of judicial controls and that they tend to use factual innocence along with other types of concerns, what do you think about that approach?
Right. Well, I have to say that I'm probably more of a fan of the hybrid approach. I mean, there's a reading of the American innocence movement which kind of says, look, due process was obviously a failure, right? Miranda hasn't prevented false confessions. There's some due process rights against suggestive identification, but we have all of these kind of DNA exonerations. I actually think that what we need to do is not throw out the due process baby with the bathwater, but also recognize that due process itself is not has not been as discriminating in picking up innocence as it should be. And so my instinct would be to kind of add, both, right? And to avoid, where possible, the battles between the two, which is why, I think the battle that's been fought in the UK between Innocence Projects and the CCRC is really quite unfortunate. I think it would have been much more constructive if the Innocence Projects had said, look, we keep putting these cases to you, they're not getting picked up. What do we need to change in terms of rules of new evidence? What do we need to change in terms of appeal standards of safety, right? So I recognize that there is a kind of tension, but I think that we should be kind of working towards a kind of inclusivity. And what I worry about some of the political economy of some of the American Innocence Projects is that they gain donations and they gain public support to the extent that they have some support from the crime control side of the ledger, right? So it's a very powerful statement in the American context for kind of a hardened prosecutor to say, I'm concerned about wrongful convictions. And of course, why he or she is concerned about wrongful convictions is, assuming a crime has been committed, it means that somebody has gone free. Whereas, in Canada, I think, traditionally, although I frankly have misgivings about Innocence Canada's change of name, and I think a lot of that was done for fundraising imperatives, of which I have some sympathy. I think in Canada we've been able to kind of balance. Yeah, we want our innocence, but we also want our due process too. But it's a delicate balance.
Yes. You have the microphone.
Thank you. Just have a question to pick up on what you said about the remedial side and how there hasn't been much work done on a remedies first approach to analyzing wrongful convictions. And I wonder if you could comment on how damages remedies or how, expunging a criminal record, how those things might drive the analysis and the distinction between factual innocence and, a rights-based conviction that as you said, may not play to factual innocence and public perception.
Yeah, well, in Canada, the federal provincial guidelines do require factual innocence, but they're often ignored. And Justice Robbins, in his report on the Stephen Truscott case, basically said, I'm not going to require factual innocence, because, of course, the Court of Appeal also did not make a declaration of factual innocence in Truscott's case, just like it didn't in Mullins-Johnson. In the UK now, there is a statutory requirement of proof of factual innocence. Now, so my worry is that if there is a hard cap requirement of factual innocence, that's going to basically limit cases to perhaps DNA cases or cases where there are other kind of definitive evidence of innocence. And of course, DNA cases, largely sexual assault, murder cases, are, obviously important, but we don't have those mechanisms for your standard run-of-the-mill robbery or so on. Now, the damage award, if you think about the Henry case, it is interesting because, damages don't have to be tied to factual innocence. Malicious prosecution tort does, but Mr. Henry got the vast majority of his damages simply through charter damages. And of course now, the issue of his factual innocence is being contested before the courts. So again, I guess what I'm saying is that a miscarriage of justice project, to borrow Ben's phrase, would be one that would be sensitive to all of these different avenues, right? And would sometimes, where the factual innocence card is present and can be played, would do that, but would also be supple in a way that recognizes that there are some cases where factual innocence is essentially unprovable, right? One of the things I've talked about in terms of terrorism, and I talk about in the paper on Clive Walker, is that, one of the interesting or disturbing things is, we've been going at counterterrorism pretty hard since 9/11. But there's no cases, been no renowned cases of wrongful convictions post 9/11 to match the Birmingham 6 or the Guildford 4. And so so then you have to ask, why is that so, right? Well, one hypothesis is it's too soon to tell, but as each year goes by, right, probably not. The other hypothesis, which is even more disturbing, is statutory inchoate offenses have basically come pretty close to defining innocence out of existence. And again, if you're living in a factual innocence world, you have no way to kind of move against that, right? And the National Exoneration of Registry of Wrongful Convictions, I looked it up this morning, they do have one terrorism case, the Detroit sleeper cell, but that was simply because the Justice Department decided to vacate the convictions because of a non-disclosure violation. And so one of my worries about a factual innocence model is it may be designed for a world that in some ways no longer exists if everything is defined as statutory inchoate offenses based upon risk levels where, how can you say that you're innocent of being, engaged in risky activity or risky association?
Any further questions? Well, if not, please join me in thanking Kent very much for a very thought-provoking presentation. Thank you very much.